This is the only matter on the calendar. It is Cortland versus Lewis County, Cortland et al., I should say, versus Lewis County, cause number 18-2-1897-34. We have, I should say, I have reviewed the briefing and many of the cases. Who do we have for the parties?
Your Honor, my name is Joseph Thomas for the plaintiffs.
All right, Mr. Thomas, good afternoon.
Good afternoon, Your Honor.
And I'm Eric Eisenberg for Lewis County.
All right, Mr. Eisenberg, good afternoon to you.
Good afternoon.
So this is was scheduled as the penalty phase hearing following a decision in favor of the plaintiffs. And I presume, well, let me just say I'm going to give each side 10 minutes. That's my expectation, unless there is reasons to go beyond that. Mr. Thomas, this is essentially, I'm going to give you the first argument as well as the opportunity for reply, given your prevailing below, well, not below, previously. Would you like to reserve any time for rebuttal?
Yeah, I'd like to reserve 3 minutes for rebuttal.
3 minutes, okay. All right, and Mr. Eisenberg, let's go ahead and have you step back so Mr. Thomas can have his space. Mr. Thomas, go ahead.
Thank you, Your Honor. This case is no different. This case is about bad faith and deterrence. Lewis County has been found in violation by the Thurston County Superior Court 5 separate times of the Public Records Act last year, and Lewis County is still asserting to this court in the penalty hearing that they're acting in good faith and that this was just an honest mistake. This is like somebody getting caught for speeding 5 separate times by the same law enforcement agency saying, look, I just kept making a mistake. And coming up to Your Honor and saying, look, I just kept making a mistake. At some point, that thinly veiled disguise has to wear off. It's no longer a mistake. Lewis County knows what it's doing. It's been found in violation of the law 5 separate times, and this court needs to issue a penalty for deterrence. There's a reason why the legislature gave this court considerable discretion to issue a penalty, and that is to deter future violations. The legislature wants agencies such as Lewis County to act in compliance with the Public Records Act, and Lewis County has not learned its lesson. It's just like that speeder saying, look, I just made a mistake. I need to get off with some sort of minimal punishment. And Lewis County, in all the 5 violations, is asking for the least punishment that it is asked for in any of these other cases. Lewis County is asking for a little bit more than a $1,000 punishment today. It's not going to learn its lesson. It didn't learn its lesson 4 previous times. This court cannot use its discretion to issue a $1,000 penalty. That's not going to teach Lewis County a lesson. This court needs to use its discretion to teach Lewis County a lesson. Otherwise, how many more times are we going to have to be in the Thurston County Superior Court? 5, 10, 20 more times for Lewis County to learn its lesson? It's getting a little bit ridiculous at the 5th violation in 1 year for a county the size of 75,000 people. It's running out of excuses. There's a pattern and practice already established with the judgments on record. So let me get into the bad faith argument. Just this week, Mr. Eisenberg sent out a copy of the transcript. Lewis County's attorney of record sent out a copy of the transcript from the merits hearing. And this is important because Lewis County's whole argument in this case is that it would violate, they can't give out court transcripts under the Public Records Act because it would violate court rules and it would violate other procedures to do it while the trial is still occurring. They can do it if the court's at the Court of Appeals. They can do it once the case is dismissed. But while the trial is still occurring, they can't give out transcripts that they purchased. But they did just that this week, and the documentation is in the email. Lewis County's attorney of record said, in order to avoid any Public Records Act requests, I'm going to send you a copy of the merits hearing in this case from November 30th, so that your clients don't file a Public Records Act request. Their whole defense is a sham, Your Honor. This is what plaintiffs have argued and the penalty brief. They never believed this at one point. They're trying to get away with a Public Records Act violation, and this court needs to set an example in this case. There is nothing more quintessential public than a court transcript. Anybody can come into court and listen to this. In fact, unless there's a countervailing privacy interest, anybody can even come in here and videotape under GR 16, as this court pointed out. As long as they're not a nuisance or anything else, they're creating some sort of distraction. And so courts are open. There's well-established case law in Washington and in the federal courts that courts are presumed to be open. But Lewis County's saying, well, when it comes to our court transcripts that we purchased, they're not open. And we're going to hide them and conceal them under the Public Records Act. That doesn't make any sense, Your Honor. These are public records. In fact, there's case law from the federal courts in FOIA, which is very persuasive. Washington courts have repeatedly held that FOIA case law is persuasive in the Public Records Act. That if a document's public and is in the public domain, and this is the public domain when we're creating a court record here, and it's being taken down and people can come in and videotape, and 2 out of the 3 court transcripts that are at issue in this case were videotaped by Mr. Green. My words were in all 3 of the court transcripts, and I don't know where Lewis County can say, look, it was just a mistake, in order to say my words were somehow in open court, were somehow exempt from the Public Records Act. Furthermore, how can they say that the judge's words in each of these cases were somehow exempt from the Public Records Act? The judges didn't close down the courtrooms. The judges didn't cite any privacy interest when making these records. There is nothing in the record in order to evidence any sort of a privacy interest. But Lewis County says, look, we made a good faith attempt at analyzing the Public Records Act in order to determine whether there was some sort of privacy interest in order to conceal these documents. There was no privacy interest at all, Your Honor, and Lewis County is making a sham defense. It's evidenced by their email this week producing the court transcript so that my clients wouldn't make a request for it under the Public Records Act. They waived their entire defense by providing that email. They said, okay, we're going to produce it so you guys don't make a request, Public Records Act request, but that was their whole defense in this case. Their whole defense is just seething with bad faith. So let me go into a couple of more instances of bad faith. When Lewis County produced these records in June 2018, I'm sorry I don't have the exact date off the top of my head, but they produced it in an email on June 2018.
June 7th.
June 7th, I apologize. June 7th, 2018. They said that they were producing it to stop the penalties. They were still maintaining their exemption, and Lewis County stated to this court, look, there's still no violation of the Public Records Act. We're entitled to withhold these because we believe the court rules provide an exemption and the defenses that are on the record at the merits hearing. It doesn't make any sense. It is completely illogical for Lewis County to produce every single record that is in dispute in this case, all 3 court transcripts, to my clients, but then still somehow claim that they're exempt under the Public Records Act from production. That doesn't make any sense because then they're in the public domain, and somehow they ended up on the internet for everybody to see. It doesn't make any, Lewis County, every step along the way in this lawsuit doesn't make any sense. Their defenses don't make any sense. And they're expecting this court just to affirm their arguments summarily. And this court, if it looks from the record, it will see that there is bad faith at every step along the way, and there's ample reason for this court to use its considerable discretion in order to penalize Lewis County in order to deter Lewis County from any future violations of the Public Records Act.
You have about 30 seconds left in your...
I just want to point out to this court that Lewis County cited RCW 42.56.290 as an exemption. It ignored 25 years of case law, construing it to mean the attorney-client privilege and the attorney-client work product. And in fact, recent appellate court cases refer to this as the attorney work product doctrine. And so Lewis County, if it took any steps in order to analyze the law and acted in good faith whatsoever, it would have known that these court rules don't apply. Stare decisis. This has been very well established by Washington courts, that this is only limited to attorney work product and attorney-client privilege. Lewis County doesn't have any legal legs to stand on. Thank you.
Thank you, Mr. Thomas. You'll have 3 minutes for your rebuttal. Mr. Eisenberg, you have 10 minutes.
Thank you, Your Honor. So I think it's important to clarify what's not in dispute. Obviously, Lewis County agrees under the law that Your Honor is to impose a per day per record penalty of between $0 and $100. And we have 3 transcripts at issue, and that they were withheld for 413, 398, and 384 days respectively. In my brief, I want to point out there was a typo where I used 394 on a couple of occasions. I'm sorry, it's 384 days. That's what was agreed on by each of our briefings. So what's at issue is, should you do a per page penalty or a penalty for each transcript as a whole? What is the amount of the penalty under Yusufian, and whether the penalty should be separate for each of the requesters, or one penalty split between the 3 requesters? You should do a penalty for each transcript as a whole. These are unified documents. They were requested as whole documents, disclosed as whole documents. They're consecutively paginated, I believe. They just look like whole documents. So it really makes sense to treat them as one record. Plaintiff's argument that you should do a per page penalty is really overlapping with the bad faith argument. That citing the gun shop case, they are really arguing that we acted in such bad faith that you should impose a per page penalty. And so I want to shift to Yusufian and say why that's not the case. If you look at the evidence in this matter, I think Your Honor will find there really isn't any evidence of bad faith. Plaintiffs have put that construction on a lot of it, but I just don't think it's supported. What you have is that when the requests came in, Lewis County claimed the exemption that we have argued about the whole time. They explained that exemption further upon request. They then stuck to that in the litigation. The exemption is that Lewis County believed that one party is not allowed to ask for a copy of a pretrial transcript from the other party when they're just using it for pretrial litigation preparation. It is analogous in some ways to work product. It isn't the same as work product, but it's a similar idea. Lewis County claimed that exemption. It tried to cite the rules that it thought outlined it. It then, when it litigated, it produced evidence of those rules again, as well as supporting case law and opinions from other lawyers, court reporters, and judges that this norm of practice existed. Now, the court ruled that Lewis County was wrong, and that's the court's prerogative. That is exactly what is supposed to happen, in fact. It's the court's job to decide uncertain legal issues. But there's a difference between being wrong and acting in bad faith. There is no case out there on this question about whether a party in Washington can demand a transcript of the other party. There's no case out there about whether the PRA exemption that says that things not available to the other side in discovery are not available under the PRA. There's no case about transcripts with regard to that. So this was an unsettled question. Lewis County reasoned from general principles and was wrong. But that doesn't mean that it acted in bad faith, and it doesn't mean that it has a particular need for deterrence. In fact, the evidence that plaintiffs claim to show or to argue that Lewis County acted in a sham way here, in fact, viewed fairly, show that it was acting in good faith. For example, when parties, including these plaintiffs, asked for transcripts that didn't fit this policy that Lewis County was articulating, like when they requested a transcript for a case that was on appeal, Lewis County produced those transcripts. There is an example of that in the record for the merits hearing. So, and similarly, the court had ruled against Lewis County's argument, and the merits hearing is one that Lewis County filed for use in this litigation. So the other party was entitled to it. And so by the same token, Lewis County offered it to the plaintiffs in this matter for free because they would be entitled to get it under the PRA, both under Lewis County's original theory and under this court's ruling. So there's nothing about that behavior that suggests bad faith. Instead, Lewis County made its claim of exemption. It had a reason for thinking so. That reason was this court ruled legally mistaken. We're bound by that ruling and we understand. I think that instead what is reflected here is the fact that the plaintiffs have managed to ask very, very tricky PRA questions. Plaintiffs argued that Lewis County has violated the PRA in other respects and therefore must be acting in bad faith. Not one of those cases makes a claim or finds that Lewis County acted in bad faith. In fact, to the contrary, in the one that I provided to you, Judge Skinder was asked to rule that we had acted in bad faith and instead ruled in a much more run-of-the-mill fashion that Lewis County had an operational problem that prevented it from getting out records because of a number of requests, and it messed up, and he imposed a very low penalty of a quarter per day per record. So that's definitely a finding that does not reflect bad faith. So the conclusion that the plaintiffs are asking you to draw does not follow from the facts before the court. I think the one key piece of evidence that Lewis County was not unreasonable in this case is the ruling that Judge Schaller made, in which she said, the county provides ample evidence that it is custom not to share official transcripts with the opposing party during pretrial discovery. So it wasn't crazy for Lewis County to think that this was the rule. It was wrong, but it wasn't crazy. And that's why I don't think bad faith follows. Because of that, $1 per day really is appropriate. If you think about the Yusufian factors, there's no economic loss that the plaintiffs have alleged. The public importance of this was rather low because plaintiffs already had the information that was in the transcript because they were there and had film of it. It was just a question about whether they were entitled to get a free copy of the transcript of that, which was less important than if, for example, an agency were hiding information that no one had access to, but in. Also, if you think about what is to be deterred here by the court's penalty, the process was actually basically the process that one is supposed to have. Request comes in, Lewis County responds within the allotted time, it makes a claim of exemption on specific legal grounds, it explains those grounds. Even if those grounds turn out to be wrong, it doesn't look as if Lewis County completely blew off its duties under the PRA. It simply claimed an exemption that was wrong. So it's not clear what the court needs to deter now that it's answered it's a question. Transcripts are not exempt. Question answered. Lewis County must abide by that ruling, and it's doing so, as you can see. So it isn't clear what extra deterrence is necessary.
Mr. Eisenberg, don't plaintiffs make a broader argument about deterrence, and they ask the court, regardless of whether there was bad faith in the previous 5 cases, if that's the number, that just this is a pattern here that requires deterrence, not this particular instance. Isn't that their argument, a little broader than the way you're characterizing it?
That may be their argument, but they provided you no evidence about those other cases from which you could draw that conclusion. I mean, I've given at least one instance in which the court explicitly found that it was not a result of bad faith.
Can't the court make its conclusion simply on the number?
I think that would be a mistake. Imagine, as I think is true, but there's no evidence in the record of this, that plaintiffs' PRA requests are very, very hard to handle, and that Lewis County has other PRA requests that it's doing okay on. That the fact that it has been found in violation of the PRA on difficult or unusual requests does not indicate that in the main it's shirking its PRA duties and is in need of deterrence. So that's why the numbers are not very helpful to you. And it's also fair to point out Lewis County has also won some of those cases. It's just that they're hard cases. So just to quickly make sure I get through the rest of the material, I want to...
You have 2 minutes.
Thank you. I want to talk about the issue of whether the requester should get separate penalties. Under the career legal case, which is in briefing before Your Honor, the...
Objection. This has already been ruled upon by Judge Schaller.
Have a seat. You'll have your opportunity to respond.
So I ask Your Honor to look back at the ruling denying my motion for reconsideration. It says that it declines to rule on other issues, this being one of those. So there's no ruling on this before. Career legal holds that only one cause of action follows from a denial. And it's about a different provision of the PRA. It's in the same statute, but it's a different subsection of that statute. But its reasoning is very similar to what would apply in this case. It says that the structure of that provision refers to people in the singular, and it suggests that a single cause of action arises. By the same reasoning as explained in the briefing, The penalty is also referred to in the singular, and it's structured in the same way, suggesting that a single penalty would arise from a single denial. So I think as a matter of law, under the career legal case, only one penalty arises. But even if that were not true, and it was just a matter of Your Honor deciding under the Yusufian factors how to apply the penalty, it is not the case that the Yusufian factors favor a triple penalty in this case. For example, the requesters did not suffer separate economic loss. They submitted the request jointly and anonymously, so there's no special notice that multiple people's request was being done wrong, or that no special notice of bad faith that we were blowing off many people. If there were a petition, for example, signed by 150 people for records, and an agency did a very bad job on that one, that might reflect extra bad faith or extra loss to those requesters, but here those factors are simply not present. So even if you decide that it's not the case that career legal disposes of the question, on the facts of this case, I think you should find one penalty for all three men split between them is the right outcome. Does Your Honor have any further questions?
No, thank you.
Thank you.
Mr. Thomas, you have 3 minutes.
Thank you, Your Honor. So, first of all, Judge Schaller already ruled on whether there's 3 separate penalties. Lewis County filed a motion to consolidate the penalty into one person, or one penalty, when it filed its motion for reconsideration. That's on the record. Judge Schaller denied it. It clearly says denied after each of the motions. And so this issue isn't before the court. Lewis County could have filed a motion for reconsideration. It did not. This is briefed in plaintiff's reply brief. This court can look it over. It's on page 7 of plaintiff's reply brief that this is already ruled on. So I won't spend any more time on that. Going to deterrence, as this court, I think, correctly pointed out, Lewis County is missing the argument about deterrence. There's 5 separate violations of the Public Records Act. Just like my analogy with speeding, how many more times does Lewis County have to get caught in order for it to sink in that they're doing something wrong? Lewis County doesn't talk about any remedial measures it took. Lewis County doesn't talk about what it changed in order to make sure more violations don't happen again. And in fact, incredibly, and this was a shock to me, Lewis County comes up for the first time and starts blaming the plaintiffs, blaming the requesters. And they said, look, these requests are really complicated to deal with. And you know what, Your Honor? There are no facts in the record to support that, and that is the first time this argument has been made before this court. There are no issues about the clarity of the request. There are no issues about Lewis County trying to go back and forth in order to discern what these requests are about. There is nothing in the record to substantiate this, and this is an ambush, and this is more evidence of bad faith in order to be blaming the requesters. Lewis County is the one that acted illegally. Lewis County is the one that violated the law. And it is absurd for them to come up and blame the requesters. They're blaming the victims. They're blaming the people who had their rights violated. This has evidence of itself that this court must issue a penalty strong enough to deter Lewis County. And $1,000 for 3 different violations is not a penalty. Each requester is denied their right to receive the request. Mr. Hoopy, Mr. Cortland, and Mr. Green were all denied their right to receive requests. The Public Records Act is a remedial statute. It provides a remedy for each person that was denied. And Lewis County comes up here and they're trying to relitigate the merits. Lewis County is talking about RCW 42.56.550 subsection 1, which talks about the burden at the merits hearing. And Lewis County is trying to relitigate the merits hearing with this court. It already had a reconsideration. It already argued the merits. It lost both times. Lewis County already admits to a violation of the Public Records Act. It should have, this is a notice pleading state, Lewis County should have put it in its answer. Lewis County had the proper time and proper place to make this argument. For some unknown reason, it chose not to, but that rests upon Lewis County and not this court. This court does not have any jurisdiction in order to rule on that today. It's already been ruled on and that time has passed. They waived it. And I think this court really needs to focus on the deterrence and the bad faith, because that's what's at issue here. And I'd like to emphasize this again. I've already said it, but I think it's a point worth making. How many more violations is it going to take for Lewis County to come in compliance? There's no demonstration that they've changed anything in their practices. There's no demonstration that they're even trying to remedy the situation. Instead, what they're trying to do is they're coming back and blaming the requesters. That should not be tolerated by this court. Thank you.
All right. Thank you. Mr. Thomas, before you sit down, let me ask you, what did you anticipate in terms of a hearing on fees?
After the order, the written order, I'll submit my, as far as attorney's fees, is
Yeah.
that what this court is? I was gonna just follow the court rule.
And
As
just
far as
note it up for
Yeah,
hearing?
I'm not prepared in order to submit anything to the court today about that.
All right, so thank you to both of the parties for your arguments here today. I am prepared to make an oral ruling today. I had kept open the possibility of something at the oral argument changing what I expected to do here today, and while I found today to be useful, it also confirmed in the court's view the positions of the parties, so I believe I can make a ruling. On November 20th, 2018, there was a hearing on the merits in this case. The court, different judicial officer, but the court made an oral ruling in which it found that plaintiffs prevailed in establishing a violation of the Public Records Act by Lewis County. On December 13th, 2018, there was an order, written order, reflecting the oral ruling that was presented. And initially, there was a penalty hearing set for February 15th, and that was continued by the court to March 1st, today's date. On January 18th, 2019, there was an order issued by the court, again, previous judicial officer, but related to cross motions for reconsideration, denying a motion for a continuance, and ruling on multiple parties question, denying motion for CR 11 sanctions, and a motion to amend the answer. And the order stated specifically there was no basis for reconsideration, no good cause to continue, and no good reason to rule on any remaining issues prior to the penalty hearing. Parties are in agreement as to some things and great disagreement as to others. With respect to the agreement, parties agree that Lewis County was determined to have violated the Public Records Act, that the plaintiffs are entitled to a penalty under RCW 42.56.550, Prans 4. And the parties also agree that the court is to determine an appropriate penalty by applying the multi-factors of Yasubian versus Sims, 168 Washington 2nd 444. Because of the importance of those factors, I am going to read them into the record. This comes from pages 467 and 468. The mitigating factors that may serve to decrease the penalty are: 1, a lack of clarity in the PRA request; 2, the agency's prompt response or legitimate follow-up inquiry for clarification; 3, the agency's good faith, honesty, timely, and strict compliance with all PRA procedural requirements and exceptions; 4, proper training and supervision of the agency's personnel; 5, the reasonableness of any explanation for non-compliance by the agency; 6, the helpfulness of the agency to the requester; and 7, the existence of agency systems to track and retrieve public records. The court goes on to discuss aggravating factors, which it lists as: 1, a delayed response by the agency, especially in circumstances making time of the essence; 2, lack of strict compliance by the agency with all PRA procedural requirements and exceptions; 3, lack of proper training and supervision of the agency's personnel; 4, unreasonableness of any explanation for noncompliance by the agency. 5, negligent, reckless, wanton, bad faith, or intentional noncompliance with the PRA by the agency. 6, agency dishonesty. 7, the public importance of the issue to which the request is related, where the importance is foreseeable to the agency. 8, any actual personal economic loss to the requester resulting from the agency's misconduct, where the loss was foreseeable to the agency. And finally, 9, a penalty amount necessary to deter future misconduct by the agency, considering the size of the agency and the facts of the case. So that's what the parties agree on, that there was a violation, that plaintiffs are entitled to a penalty, and the multi-factors the court is required to consider. The parties, of course, have very different views on what the application of these factors mean with respect to the resulting penalty. Plaintiffs want $10 per page per day for each request, which they total to be $349,970, tripled for each requester, as I read their request, to essentially $1,050,000. The defendants propose $1 per record per day, which with their math total $1,195. Clear difference of opinion as to the appropriate penalty. While the case law sets out the factors, it's also clear from these cases that the court retains great discretion and flexibility in applying the factors. Yusufian itself says on page 468, quote, "We emphasize that the factors may overlap, are offered only as guidance, may not apply equally or at all in every case, and are not an exclusive list of appropriate considerations. Additionally, no one factor should control. These factors should not infringe upon the considerable discretion of trial courts to determine PRA penalties." So I read these authorities and instructions to consider the totality of the circumstances and assess a penalty holistically by only focusing on those factors that would appear to apply. In fact, that's language used from Division 3 in a recent Court of Appeals decision, Hoffman versus Kittitas County 4, Wash App 2nd, 489. It characterized what Yusufian did as a holistic exercise considering the totality of the circumstances. Now, while I understand that both parties have their different perspectives on the relative factors, I started by considering all of the factors with the record that the court had before it. After I considered all of the factors, I determined that several of them on this record, under these circumstances, were relevant to the court's consideration, and others were not. And some of the factors were relevant because of their presence, and some were relevant because of their absence. I'll try to explain what I mean. With respect to those factors that I found relevant, either because of their presence or absence, I'll start with the aggravating factors. Factor 5, negligent, reckless, wanton, bad faith, or intentional noncompliance, I found to be relevant. Factor 7, public importance. Factor 8, economic loss to requester. And Factor 9, deterrence of future misconduct. With respect to the mitigating factors that I found to be relevant, either because of their presence or absence, I would list out Factor 2, the prompt response. Factor 3, good faith, honest, timely, and strict compliance. And Factor 5, reasonableness of explanation. Now, the rest of the factors I found on this record were not applicable or not relevant in my determination of the penalty. So let me try to describe how I found those that I just listed relevant. At its very root, this case is about, in my view, Lewis County asserting an exemption that it thought applied, or it said it thought applied, and in fact, as decided by the court, that exemption did not apply. The county was clear, as I understand it, prompt and understandable in its explanation, but it was wrong. Understandable in its explanation, in that one could understand the explanation, but it was wrong. Now, as for the aggravating factors, factor 5, which is the negligent, reckless, wanton, bad faith, or intentional noncompliance, the plaintiffs have argued in their briefing and in oral argument here today that this was clear bad faith by Lewis County, and they have a variety of reasons why they believe it to be shown to be bad faith. I'm not persuaded on this record and by argument that Lewis County was acting in bad faith or with intentional noncompliance. I am not, however, necessarily persuaded that there wasn't an element of recklessness to their decision, and that is within the string of words used in factor 5. To some extent, that recklessness overlaps, to use the Yusuvian description, overlaps with factor 9, which is deterrence. I'll get to that in a moment. Factor 7, which is public importance. As I look at the facts of this case, the underlying decision that these transcripts were public records, I can envision, although I'm not going to ask the question and it has not been offered to me, I can envision that this decision might be appealed. But regardless, this decision could have broad application to all kinds of government agencies who are involved in litigation. That doesn't necessarily speak to potential bad faith by the agency, but it does speak to the significance of the issues presented in this case. Factor 8, economic loss. This I would characterize as being relevant because of its absence, not because of its presence. I think even plaintiffs concede in their briefing that they did not argue economic loss and therefore shouldn't be considered. However, I think it's more accurate to say the court considers the absence of economic loss as part of its evaluation of an appropriate penalty. Factor 9 of the aggravating factors, the deterrence of future misconduct. This plaintiff focuses on, in addition, of course, to bad faith, but they focus on deterrence, both in their briefing and certainly underscoring the need for deterrence in argument here today. And the defendant says, well, we don't need to be deterred. We know what the rule is now. We're applying it now. So what's the deterrence that's relevant here? As I view the circumstances, I think the defendant reads this factor too narrowly, in my view. The plaintiff's argument that the sheer number of recent violations against Lewis County is somewhat persuasive. I get that the defendant does not believe the court has enough information from which it can make that judgment. And certainly the court has no information about whether there's bad faith involved in any of those previous decisions, apart from the one that the court has some evidence that there was no bad faith found by the court. But I do believe that it is relevant to consider deterrence when you have a sheer number of violations found, as it overlays the defendant's decision to interpret exemptions in a way that it has risk. So when a defendant is left to consider whether an arguable exemption were to apply, a decision to withhold, even if it's not a result of ill will, would potentially have an element of recklessness to it when it is also being found in violation in many other circumstances with or without the same requesters. In any event, this deterrence factor in the court's view is the most relevant to us as an aggravator as opposed to some of the others discussed. In terms of mitigating factors that I had listed earlier, factor 2 was the promptness of the response. As I understand the record, Lewis County was prompt. Factor 3, whether there was good faith, honest, timely, or strict compliance. Again, this is a kind of a swinging door with the aggravator factor regarding bad faith and recklessness, but I'm not persuaded that there's anything in the record that would suggest that Lewis County was not sincere in their mistaken belief. Reckless maybe, but not dishonest or insincere about it. Factor 5, the reasonableness of explanation. This one is interesting because when an explanation is legally incorrect, is it reasonable? And that's why I said earlier, it's an understandable explanation that was given by Lewis County. I understand the argument that was made, why it was withheld. Is it reasonable when it's illegal? I don't know. This is analysis of this factor is one which I think the Eusebian factors would instruct the court to sort of consider holistically, as opposed to being determinative directly because it's unreasonable or reasonable. In any event, I guess let me restate that. Lewis County gets some credit for the clarity, gets some discredit for its incorrectness. So those are the factors that I find were most relevant to the court's consideration of an appropriate penalty. The most significant disagreement, if one were to look at the extremely large number from the plaintiff's request, and I'm going to use, just to be symmetrical, the extremely low number from defendant, is this per page versus per record difference of opinion. Defendant has a per transcript request, plaintiffs have a per page request, and that's what really drives the difference of the numbers. I think that's a more appropriate way of putting it. In reading Wade's East Side Gun Shop, which was the case cited to the court, that's 185 Washington 2nd 270. It's very clear to me that the court has an authority to go either way on this. And that court did not give a lot of direction to how to make that decision, apart from being informed by the application of the Eusebian factors in general. So that I liken that particular decision to similar to the same decision of where the per day fee is going to be. So again, we have the parties have very different views of the appropriate penalty. Plaintiffs want $10 per page per day times 3. Defendant wants $1 per record per day times 1. And we'll get to the 1 penalty or 3 penalties in a moment. So when I look at all of the Eusebian factors and view them with the vast amount of discretion the court has, but in attempting to utilize those factors in the way I've just discussed, here's where I come down. First, a per record penalty is appropriate. Each one of these documents are conceptually standalone documents. while that's not dispositive, I think that's a place to start, absent some indication from applying the Yusuvian factors. And here I don't find sufficient aggravating factors to shift the penalty from a per record to a per page penalty. So while I agree with the defendant that the penalty should be per record, I don't agree with the defendant as to their per day penalty. As I mentioned above, the most compelling aggravating factor for the court is deterrence of future misconduct. I do read that application of that factor more broadly than does the county for this case. On the other hand, I don't see the bad faith the plaintiffs strongly believe that is present. So, considering that factor, together with all the other aggravators and mitigating factors I discussed, I arrive at a $10 per day penalty, which means the total penalty, $10 per record per day for the 3 requests, turns out to $11,950. The question then becomes whether or not there is one penalty or a per requester penalty. Now, the plaintiffs argue that this was already determined by the court in its January 18th order, or, in the alternative, I suppose, waived by the county's failure to appropriately raise this issue earlier. The defendant, on the other hand, cites the Creer legal case, and I think accurately states that it doesn't answer the question directly. It is strongly indicative that the answer should be a single penalty. And that case is Creer Legal versus Monroe School District 4, Wash App 2nd, 776. With respect to the plaintiff's argument, I'm not persuaded, given that this is a legal issue that did not ripen until the penalty phase, that the defendant has waived their right to argue a single penalty. I'm not persuaded by that. I'm also not persuaded that the court ruled on this issue in its January 18th, 2019 order. In fact, I read that decision as specifically not making a ruling in that case. When the court said on line 22 of the first page of that January 18th order, its decision that there was no good reason to rule on any remaining issues prior to the hearing on February 15th. Any remaining issues I view as the decision of whether a single penalty would apply or a triple penalty would apply. So I think the legal issue is squarely before the court of whether there's a single penalty or a multiple penalty depending on the number of requesters. I don't find that there's been a dispute over whether there was 3 requesters or not. I think that plaintiff has, to the extent it was necessary, shown that there was 3 requesters in this case by the declarations that have been filed. But I'm not persuaded that matters. I'm more persuaded by the language from the Creer legal case when it said on page 781, quote, "We read the act to provide for a single cause of action arising from an alleged PRA denial, regardless of how many individuals were involved in making the request," end quote. That's on page 781. This is an interesting issue that I may be wrong on, and certainly if I am, the Court of Appeals will tell me so, but I don't find that there is a basis under the PRA to have multiple requesters of the same cause of action get multiple penalties. There is but one penalty that is appropriate, and that's the court's decision. How the plaintiffs decide to divide up that penalty is up to them. So, that will be the court's ruling. I do, and then I asked Mr. Thomas at the outset about his request for fees. That is a remaining piece to this litigation that needs to be determined. I assume Mr. Thomas will note up his request for fees as on the civil motions docket, and the county will have an opportunity to respond. Mr. Eisenberg, you have, based on the valuation of the request, predominantly prevailed. I assume you will draft the court's order. The court does not expect to draft its own order in this regard.
I will be happy to do so.
And you, of course, will share with Mr. Thomas, and if Mr. Thomas has disagreement with the form of the order and the agreements cannot be arrived at, you can note it for presentation and argument. So that will conclude this matter. Anything remaining on this matter, Mr. Thomas?
No, Your Honor.
Mr. Eisenberg?
No, Your Honor, thank you.
Okay, there being nothing further, we shall go off the record. Everybody have a good rest of your day.